Thank you. We're reconvening after the lunch break. The court had distributed preliminary jury instructions to the parties prior to taking a break over the lunch hour. My intent would be to review the preliminary instructions with the jury immediately when they come into the courtroom prior to opening statements. Does the state have any modifications or objections to the preliminary instructions?
No, sir.
Does the defense?
No, sir. Thank you.
And in terms of the opening, is the state prepared?
Yes, Your Honor.
Will you need to utilize any media or any technology as part of your opening?
No, just the podium.
Thank you. Is the defense prepared for opening?
Yes.
And will the defense need to use any media or any technology as part of your opening?
Yes, sir.
Computer projection? You're going to use the computer to project?
Yes.
You verified that that's working?
You have, it's working. You checked this morning.
This morning we checked.
Okay.
Do you want to double check?
Sure.
Why don't we do that? I've directed that the jurors be lined up in the back hallway. It's going to take a minute, so let's just make sure that technology is working. It's not the first time that I've had it work in the morning and not in the afternoon. I don't know what that means, but it seems to be the courtroom.
There we go.
Is that right?
Yes.
Have you tried, is there any sound?
There will be sound, yes.
Have you tried sound?
We have not, no.
Let's try sound. Sound works. Okay, as soon as the civilian bailiff has them lined up, I'll bring them in. Is there anything that the state feels I need to address before that?
No, Your Honor.
Anything this defense feels I need to address?
No, Judge. Thank
All right.
All right. All right, please be seated. Welcome back, ladies and gentlemen. Before the trial begins, there are certain instructions that you should have to better understand your functions as a juror and how to conduct yourself during the course of the trial. Your duty is to decide the case based only on the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence Do not let any personal feelings about race, religion, national origin, sex, or age affect your consideration of the evidence. Do not begin your deliberations and discussions of this case until all the evidence is presented and I've instructed you on the law. Do not discuss this case amongst yourselves, or with anyone else until your final deliberations in the jury room. We may stop or recess from time to time during the trial. You may be excused from the courtroom when it's necessary for me to hear legal arguments from the lawyers. If you come into contact with the parties, the lawyers, or the witnesses, do not speak with them. For their part, the parties, the lawyers, the witnesses will not speak with you. Do not listen to any conversations about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit any scene. Do not read any newspaper reports or listen to any news reports on radio or television about this trial. Do not consult dictionaries, computers, websites, or other reference materials for additional information. Do not seek information regarding the public record of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you were serving on this jury. Don't use a computer, a cell phone, or other electronic device with communication capabilities to share any information about this case. For example, don't communicate by blog or email or text message or Twitter or in any other way on or off the computer that I have no capacity to do myself. Do not permit anyone to communicate with you, and if anyone does so, despite you telling them not to, you should report that to me. I appreciate that it's tempting when you go home this evening to discuss this case with another member of your household, but you may not do so. You can make Judge Domina the bad guy. Tell him people in your family that he's a meanie. He's a grouch, and he won't let me talk about it. People not serving on this jury have not heard the evidence, and it's improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and to the taxpayers. You are to decide the case solely on the evidence offered and received at trial. Is there some kind of mechanical recording? I'm picking that up for some reason. Is it turned up?
Yeah, I can turn it.
Can you turn it down? Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which I've directed you to find. Anything you may see or hear outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, The court is not indicating any opinion about the evidence. You, jurors, are the judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during this trial, except during opening statements and closing arguments. I will provide you with the material. In taking any notes, you must be careful that it does not distract you from carefully listening to and observing the witness. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, your notes will be collected and destroyed. You will not have a copy of a written transcript of the trial testimony available for use during your deliberations. You should therefore pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and the testimony introduced during the trial. During the course of the trial, the attorneys may refer to or use police reports with a witness. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. It's the duty of the jury to scrutinize and weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon a witness's race, national origin, religion, age, ability, gender identity, sexual orientation, income level, or other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during this trial which tend to either support or to discredit the testimony. Then give to the testimony of each witness the weight that you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things that people say to you. You should do the same thing here. The first count of the information in this case charges that the defendant, on or about Saturday, June 17th, 2023, at 111 East Capitol Drive in the village of Heartland, Waukesha County, Wisconsin, did cause the death of an individual identified as victim A while committing battery bodily harm. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. When reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The lawyers will now make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. First opening statement will be given by the state. Ms. Delafield.
Thank you, Judge. Good afternoon, everyone, and thank you for being here today on behalf of myself and the Waukesha DA's office. We thank you for your service for this jury. And as the court just said, this is a one-charge felony murder. And as the court just told you, I must prove those charges to you beyond a reasonable doubt. And just essentially what that all means is that this defendant, Kevin Sehmer, committed the crime of aggravated battery against the victim, in this case, Josh Davies, simply meaning he caused great bodily harm to Josh Davies. And as a result of that aggravated battery, as a result of causing him great bodily harm, Josh Davies died. That's essentially what this case is about. And it's really about what happened to Josh Davies that night. And the state believes that the evidence will show that the second Kevin Sehmer, this defendant, saw Josh Davies, he had it out for him. Kevin Sehmer was aggressive both verbally and physically for the very short time that Josh and Kevin were in contact with each other this night. And we believe that the evidence will show that this defendant punches Josh in the head, causing Josh to drop to the ground, hit his head on the concrete again, which ultimately led to Josh's death. And you will first hear testimony from Officer Tyler Martins, Heartland Police Department. He will tell you that this all occurred on Saturday, June 17th, 2023, a very classic Wisconsin summer evening. There was an outdoor concert at Beer Snobs down in downtown Heartland. Part of the street had actually been closed down. Officer Martins was there patrolling the area, and he'll explain to you where this area is, the general setup of this area in downtown Heartland, the bars around there, and he'll show you some maps, and we'll go through it so you can orient yourself to all the places. Towards the end of this night, June 17th, 2023, around 11 p.m., maybe a little bit before, Officer Martins, while he's on routine patrol, gets flagged down by a group of individuals on the sidewalk in front of Tabby's Bar and Hometown Pharmacy at 111 East Capitol Drive. And Officer Martins will tell you there was a male lying on the sidewalk. That male was Josh Davies. Josh Davies was surrounded by two different people, his wife, Jen Davies, who will testify, and his friend, Brian Richardson, who will also testify. And essentially, there are 4 civilian witnesses in this case and some videos that will show you exactly what happened to Josh Davies that night and why he ended up laying on the sidewalk, which ultimately caused his death. And those 4 civilians are Jen Davies, like I just told you, the wife of Josh Davies, Brian Richardson, the friend of Josh Davies, Laura Burke, a friend of Jen Davies, and someone completely unrelated to Jen, Brian, Laura, and the defendant, John Laporte. Now, Jen Davies and Laura Burks, they will tell you, they've been friends for several years. Jen does Laura's hair. They will tell you they decided to meet up for this concert at Beer Snobs that night. It's an outdoor concert. Jen had come there with her friend, or with her husband Josh and Josh's friend Brian. They were out there enjoying the concert. And Laura Burke will tell you that she was out there, she was at the concert, and before meeting up with Jen, Josh, and Brian, she was just walking around, you know, talking to people. Eventually met someone she didn't know, but struck up a conversation with them, and that person was Kevin Sehmer. Kevin was there with his friend Tom. Laura starts talking to them. Kevin's kind of trying to set Laura and Tom up. And Laura will tell you she never met Kevin before this night. She doesn't know him, never met him before this night, never met Tom before this night. But they were talking throughout the night on and off outside at this concert. Kevin even puts his number in Laura's phone. Laura then connects with Josh, Brian, and Jen, the people that she agreed to meet up with. And, you know, they're outside, they're enjoying themselves, as I'm sure we all have on a Wisconsin night outside in the summer. Towards the end of the night, as the band outside is getting done, getting closer towards 10:30, 11 p.m., Jen, Laura, Josh, and Brian, those four, decide to go to Tabby's Wine Bar. And again, Tabby's Wine Bar is in the same general vicinity as Beer Snobs. They walk to it, still in downtown Heartland. And Tabby's Wine Bar actually has video surveillance inside that is both audio and sound. And you will see on this video surveillance Kevin Sehmer at the end of this bar, and you will see Jen and Laura walk in first from the back, and then you will see Josh, the victim in this case, and his friend Brian walk in from the back. And they walk all the way across, and you will see on the video that they end up meeting at the end of the bar with Kevin. So now it's these five together in Tabby's Wine Bar. And you will also see in the video that other witness I talked to you about, John Laporte. John was a musician playing at Tabby's that night, separate concert from the one at Beer Snobs. He has no relation to Mr. Sehmer, the defendant, no relation to Laura Burke, no relation to Jen Davies, no relation to Josh Davies, no relation to Brian Richardson. Doesn't know any of the five people involved in this. And he was at the end of the night, and he was at the end of his concert, and he's packing up, putting his instruments back in his car, so he's kind of walking in and out of Tabby's is what you'll see. And what you'll also see in that video and what you'll hear from the witnesses is that almost immediately this defendant sees Josh and starts making comments about Josh and his tattoos, marking up God's work. And Jen and Brian, they'll tell you, and Laura will tell you, they've never met Kevin before. They don't know why he's going in on Josh and tattoos, and they'll kind of tell you they thought maybe Kevin was just joking. They didn't think much of it. And you'll see after this initial interaction on that Tabby's Wine video between Josh and Kevin, Josh separates himself. Josh goes to a different side, separates himself from Kevin. Kevin continues to be aggressive with Josh. You'll hear on the Tabby's Wine video him say F you to Josh, go out there and practice falling down, saying that to Josh. And I want you to listen to Kevin's tone, Mr. Sehmer's tone when he does that. It's not a joking tone. You'll see his demeanor. You'll see him be aggressive with pointing. You'll see this on the video. And even during this second interaction between Josh and Mr. Sehmer, you will then see Kevin walk over to Josh, get in Josh's face, say, shut your effing mouth, pointing in Josh's face. Josh stands there. Josh doesn't, you're not going to see Josh make any aggressive moves toward Kevin in this Tabby's Wine video. John Laporte, the musician who was walking in and out that you'll see in that video, will tell you how he heard the defendant making these statements towards Josh Davies that night, heard swearing, heard those things. Now after Mr. Sehmer gets in Josh's face that second time, you'll see on the video, you're going to hear from Jen Davies, hear from Brian, hear from Laura, that basically Jen kind of has Josh and Brian leave the bar. It's towards the end of the night anyway. She kind of has them go outside. So yet again, you'll see Josh separate himself from Mr. Sehmer. Now, on the video, you'll see Jen and Laura. They're going to remain inside with Mr. Sehmer for a little bit. And eventually you'll see Josh Davies on this Tabby's Wine video again, standing at the door. Doesn't go past the front door, doesn't come back into the bar necessarily. And he makes a comment to his wife, Jen, "Are you still talking to that a-hole?" And this is when this whole incident really starts to happen. Like I said, in this video, you're not going to see Josh go beyond that front door. You're not going to see Josh come at Mr. Sehmer. You're not going to see that. You're going to see Kevin rush out directly towards Josh from the wine bar. You're going to hear from Jen and Laura. You're going to see on the video that Kevin pushes past Jen and Laura to try to get to Josh. You'll even see Laura try to grab Mr. Sehmer's shirt to keep him back from going outside. You'll see Jen standing at the door, that front door to Tabby's Wine Bar, to try to keep the two separated. And once Kevin goes outside, everything happens very quickly. Now, what happens outside on the sidewalk where this aggravated battery occurred, it's not going to be as clear as the video from Tabby's Wine. You will see some video from Hometown Pharmacy. It's directly next to Tabby's Wine Bar. And Officer Luke Jozwick with Heartland PD, he went and got the video from the owner of Hometown Pharmacy. Now, this actual camera is actually inside the pharmacy, inside the store, and it points out through the windows towards that sidewalk. And so the view from the Hometown Pharmacy video is going to be through the window, and you can kind of see some of what has happened between Josh and Kevin on that sidewalk. Again, it's not going to be perfectly clear, but you are going to see some things. And James Armstrong with the State Crime Lab, he's a forensic imaging specialist there. He enhanced the video in certain ways so that you can see better, so that you can see the parties better. And at the end, the state believes that that Hometown Pharmacy video will show Mr. Sehmer advancing towards Josh, Josh backing up as Kevin continues to approach him, and then Josh falling to the ground. And then you'll see Kevin walking away. Now, the four civilians, Laura, Jen, Brian, John Laporte, they're going to fill in what that Hometown Pharmacy video doesn't show clearly. Jen, Brian, and John were all outside somewhere on the sidewalk, but in different positions, and observed the altercation, observed Mr. Sehmer advance towards Josh and hit him. They're also going to talk about how there was a stool involved. There were stools that were in front of Tabby's Wine Bar. You'll see them on some photographs, that there was a stool involved in that. And on the Hometown Pharmacy video, I believe you'll also see the stool fall to the ground when Kevin and Josh are advancing towards each other. Now, Laura, she was still there, but she was still inside Tabby's. So she did observe some of what would happen from their vantage point. And after Josh falls to the ground, Jen, his wife, will tell you that he was taken to the hospital. He was there for about a month, but ultimately he died from the injuries that he sustained on June 17th of 2023. Dr. Linda Bedricki, hopefully I say her name right, but she'll clarify that for you. She's our medical examiner in Waukesha County. She's been the Waukesha County medical examiner for about 26 years now. She's also a medical examiner in Washington County. She has extensive training and experience on forensic pathology. She'll testify that she was the one that ultimately conducted the autopsy on Josh Davies. And she will tell you that Josh Davies died as a result of the head injuries from this night on June 17th of 2023. Now, Detective Paula Hoffa, she's sitting at the table behind us. She will also testify. She was called in that night to assist in the investigation. She was one of the lead investigators on this case. She learned that this defendant, Kevin Sehmer, was involved, and she even went to Mr. Sehmer's house that shortly after, hours after this incident, so the morning of June 18th, 2023, pounded on his door, tried to make contact with him, unable to. No answer from Mr. Sehmer. Other officers who were on scene that night, Officer Tyler Martins, he will tell you that they also looked for Mr. Sehmer that night to try to figure out what happened. Couldn't find him. Now, there's some things that the evidence won't show because there's certain things that the state doesn't have to prove. And one of the biggest things is exactly why Mr. Sehmer did this to Mr. Davies. The state doesn't have to prove why Mr. Sehmer committed this crime against Josh. Doesn't have to prove what his motive was. We just have to prove that he committed an aggravated battery against Josh Davies, and that led to Josh Davies' death. Why Kevin got so mad at Josh from the beginning, that might not be an answer that we have. But I also want you to remember, that's not necessary to finding out if the defendant committed this aggravated battery, which resulted in Josh's death. What the state believes that this evidence will show through the witnesses, through the videos that you're going to see, is that this defendant violently attacked Josh Davies that night, hit Josh, causing Josh to drop to the ground, hit his head on the concrete, and ultimately led to his death. And at the end of the case, DA Opper, she'll come back up here, and we'll ask that you find the defendant guilty of the sole count of felony murder. Thank you.
The next opening statement will be given by defense attorney Shiro.
Thank you.
This case is about somebody trying to hit my client with a stool. And my client stopping this person from doing so by stopping the momentum of the stool as it came rushing towards him as a result of Mr. Davies' actions. Videos actually tell us a lot more, I think, than what the state is suggesting. A lot more. While I have seen more clear videos, more clear movies, I've seen movies that I've made that were better than this. But they're going to tell us something fairly important. Now, it is true that my client and Mr. Davies got into a stupid argument that was mostly, quite frankly, my client's fault. I mean, it was stupid. And you're going to see that, as counsel said, she wasn't wrong. My client was weirdly angry about this tattoo that Mr. Davies had. I don't know why he cared so much, but it seemed stupid, seemed not really appropriate, quite frankly. And at some point, my client goes and pokes his finger at him, calls him a name, and at some point, his wife, Jen Davies, suggests and kind of tells Josh and his friend to leave. I'm not suggesting that she did that because she was thinking that her husband had done anything wrong. She just thought, let's separate this. But this argument ended then, okay? That it was over. What you're going to see is that not only was it over, but my client was actually talking with Mrs. Davies and with Laura Burke, and they were having a very friendly, quite frankly, discussion. Such though that at some point my client appears to be kind of hugging both Ms. Burke and Ms. Davies. This is what happens at about this. He's already left. That is, Josh is already left.
seat.
Can you just stop for 1 second? On the left is Ms. Davies. On the right is Ms. Burke, the two women that my client's the big guy behind them, and he's talking to those two. Okay?
I needed a seat. Maybe you guys are actually really good friends. I've known Johnny forever. 20 years. 20 years. Yeah, it's been a lot. I like John. Maybe you're taking it. Maybe she's
I'm serving around the pilot.
Maybe she's
Don't take it personal. What did you say?
We just saw in that upper left corner, that was Mr. Davies. He came back in. This argument was over. In fact, you just saw, and the evidence will show, that my client was kind of hugging Ms. Davies and Ms. Burke. And Josh came in and yelled some profanities because he appears to be angry that his wife is still talking to Mr. Sehmer, and perhaps that Ms. Burke is still talking to Mr. Sehmer. And then my client goes out that door and yells and says something like, "What did you say?" and then runs out. That's what happened, okay? Now, Mr. Sehmer, when he goes outside, go ahead. You're going to see that he's obviously upset. Jennifer Davies and Laura Burke try to go outside, and they go outside. Now, Ms. Davies is going to tell you, Josh's wife, that her husband picked up a stool and put it over his head. That's what they say. And Ms. Burke sees things. She says, Ms. Burke, remember there was the two ladies, there was Ms. Davies and Ms. Burke. She says, "I saw through the window that Josh had a chair raised above his head to hit Kevin as he approached." Okay? This is really what happened. And further, that Ms. Davies says her husband picked up a chair and stood to defend himself. So I know the state has told you that my client, poked his finger and was being kind of obnoxious, and he was. What he didn't do is try to pick up a stool and hit somebody with it. He used words, or he poked his finger. That's a lot different than somebody picking up a stool and going after somebody. Now, so we have the two principal witnesses, I think, are going to tell you that when my client went outside, after he, Josh, decided that he was upset that my client was having a friendly conversation with his wife and Ms. Burke, he decided he was going to make this physical. Go ahead. And the video is going to show you something. I want you to see this. But if you could just stop for a second. What you have to do, really, ladies, this is that, and gentlemen, this is the photo through the pharmacy, okay? Now, if I had a good little pokey thing, I could show you that. What you're going to see is two people are moving from right to left. And the witnesses, either the officers or a number of people will say, well, from the right is the door to Tabby's, okay? That's where both Josh had gone out, came back in and yelled, and then left. And Mr. Sehmer is coming out, okay? From right to left. Stop. That's Mr. Davies. See him backing up, okay? And it probably would have been a little harder, but you could have also been able to see Mr. Sehmer, a larger person with a white light shirt, moving. Go ahead. Now look, stop. Did you see, that video just showed you Mr. Davies.
Jack, that's argumentative and for closing, Your Honor.
He says this is opening, it's intended to demonstrate what each side thinks the evidence will show. The court overrules the objection. You can continue with the opening statement.
Thank you. Obviously, it happened kind of fast. I won't back it up. But what you saw, and when you see it again, in various configurations, by the use of law enforcement and the state crime lab and trying to make this, you're going to see one thing that's clear in every single one, that as my client and Mr. Sehmer are both moving from right to left, Mr. Davies launches himself at Mr. Sehmer. And remember, his wife has told law enforcement, and Ms. Burke told law enforcement, that he had a stool above his head to attack my client. The only violent act that was shown, that will ever be shown to you in any of the videos, is not my client going after Mr. Davies, but Mr. Davies lunging with a chair in his hand at my client, and that he then goes down. Now, and when I say goes down, I don't mind to minimize this, because it is Mr. Davies' fall to the concrete that caused his death. Now, I understand that there's at least a couple witnesses who claim that it was my client punched him, but the video evidence will be uncontroverted that it was actually Mr. Davies moving towards my client. And that the evidence, I think, will establish that Mr. Davies fell to the ground for 3 reasons that are, I think, sensible, logical, and irrefutable. First, Mr. Sehmer stops Josh from hitting him with the stool that he's got in his hand. That, if we look at, actually look this up, Newton's law, third law of motion, act that causes force will be met with resistance, and they sometimes are equal, sometimes they're not. So if somebody tries to hit you with a stool, and that person is able to stop that momentum, that motion, that energy has to go somewhere, and it's going to go into Mr. Davies, who then falls down. That's one reason. The second reason is that in another video, and we won't do it all now, but later, you're going to see that it appears that Mr. Davies actually is tripping as he is jumping, launching himself towards Mr. Sehmer. That's another reason that we see him falling. And thirdly, you're going to find out that Mr. Davies was grossly intoxicated. Not a little intoxicated, grossly intoxicated. You are going to find from the evidence of both the medical examiner as well as Dr. Ronald Henson, who I'm going to call, that the medical records show that Mr. Davies, when he went in, his blood alcohol level was somewhere between 2.4 and 2.67, depending upon whether the alcohol testing was done by serum or whole blood, and neither know exactly, so there's a range. But the minimum range is over, I think, 2.4 or 2.2, and as high as 2.67. And Dr. Henson, who has been working in this field involving alcohol testing and alcohol and arrests, he was a former police officer. you will learn his credentials and how he deals with people with alcohol and drug issues and their impact on people. And he's going to tell you what, quite frankly, all of the nurses and medical people on this jury know, that when somebody gets really drunk, not a little drunk, when they get well over 2-0, their ability to move, to coordinate, to keep themselves in position as they're launching themselves at somebody is impaired. So this person who tried to attack somebody may have fallen over a stool and was also very, very drunk, fell to the ground, not because of a battery, but because he tried to attack my client. And my client may have been acting like a jerk, but you can't attack a person with a stool. And remember, this was, as the evidence indicated, this argument was over. Now, as you're going to learn, as you probably aren't surprised, is that my client, as does every person, has a right to defend themselves from an unlawful interference. Sometimes that might be kind of vague in terms of, well, what interference are we talking about? That's not really a circumstance that we have to concern ourselves too much here. Because the interference is, you don't get to hit me with a stool, a metal stool, by the way. You don't get to do that. I don't have to take it in the face because I said I was mean to you earlier in the night. You have a right to prevent that. And you have a right to put up your hand and stop yourself from being struck. And that's an unlawful interference. You don't get to hit somebody with a stool. And again, this isn't, my client saying he hit me with the stool. This is Ms. Davis saying that he did that. Ms. Burke said he did this. And it is fast. Okay, the evidence will show that this whole incident goes very, very quickly. Okay? And it is terrible because, somebody hit their head. But he didn't hit their head because my client battered him. And the judge is going to tell you that if my client is preventing somebody from interfering, as Mr. Davies was by trying to hit him with a stool, not only does the state have to establish that there was this battery, but that my client didn't do so, exercising his right of lawful self-defense. In other words, they have to prove that he didn't have the right to do that beyond a reasonable doubt, and we don't get, and you don't get to when you're examining the evidence, think, well, how would I have reacted today? No, it's at the time of the event, that's when you look. Was he acting reasonably in stopping this person from hitting him with a stool? I would say at any time anybody can do that, but the government has to disprove this. And I think when you're done and you look at these videos, and unfortunately you're probably going to see these videos numerous times because law enforcement, as counsel indicated, did some efforts to try to make it more visible. And the more clearly we get this, the more clear it is that Josh Davies fell while trying to attack my client. And he fell because he was trying to swing an object, which my client stopped. He tripped, perhaps, and was exceedingly drunk and couldn't do that without falling down. And I'll be asking that you find that he properly exercised his right to defend himself and that you will find him not guilty. Thank you.
Stay prepared with this first witness.
Yes, the state calls Officer Tyler Martins.
Officer Martin, would you come forward, please?
stand us behind the court reporter. Step up there, raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Have a seat. Black bar with the red light is a microphone. I'd ask you to keep your voice directed to it.
All right.
Can you hear the level of my voice?
I can.
Yes, that you keep your voice up so we can all hear you. Counsel, this is your witness.
Thank you, Judge, and we will be using one of our computers at the back table,
So you want it switched over?
yes, Your Honor.
All right.
But I can continue with questioning, I just wanted
Yep,
your
I think
clerk
we've
to
done
be
it.
there.
Go ahead.
Got it. Officer Martins, how are you employed?
I'm employed with the Village of Heartland Police Department as a police officer.
How long have you been with Heartland PD?
Approximately 2 years.
And what are your general duties, or what's your role?
I work routine patrol.
Okay. And do you have a certain shift that you work?
I worked third shift and just switched to second shift.
What's third shift? What time?
Third shift is 10 p.m. to 6:20 a.m.
And second shift?
is 2 p.m. to 10:20 p.m.
So you upgraded to second shift?
I did.
Okay.
Yeah.
And in order to become a police officer in the state of Wisconsin, did you go through the basic police academy?
Yep, I went to a police academy and then I graduated and started patrol a week after.
And where did you go to the police academy?
Waukesha County Technical College.
And what year did you graduate?
I graduated in 22.
After you went to the police academy, did you become a certified law enforcement officer?
I did.
And since your graduation in 2022, have you maintained being a certified law enforcement officer in Wisconsin?
I have.
Okay. Now, I want to draw your attention to Saturday, July 17th of 2023, June. I apologize, thank you. June 17th of 2023. Were you working as a Heartland Police Department officer at that time?
I was.
And were you working third shift?
Yes.
Okay. So that night, were there any festivals or outdoor concerts going on?
There's a little festival that one of the restaurants downtown holds. It's called Snobs Fest. It's ran by Beer Snobs, which brings in a concert and a decent-sized crowd.
And Beer Snobs is located on what street?
It's on Haight,
On Haight,
which is right off of West Capitol and Cottonwood.
okay? And was Haight Street closed down at all for this festival?
Yeah, because that's where they set up a concert and the whole stand is, the road's shut down
Okay.
for that part.
And so I want to bring up exhibit number 1. So are you able to see exhibit 1 on your screen right now?
Not yet.
Nope.
Just a minute. It's up.
Okay, and do you know what exhibit 1 is?
Yeah, that's a overview of the location. It's got West Capitol Drive and then East Capitol Drive.
Okay.
And then Haight Street's on there as well.
And is that a fair and accurate map of that area?
It is.
I would move exhibit 1 into evidence and request to publish to the jury.
Any objection?
No.
Exhibit 1 will be received. You may publish. Ladies and gentlemen, just tell me if that's in your jury box. I'm going to hope that that's the way it's going to work the whole time you're here with me. Go ahead.
Thank you, Judge. So let's first start off with, let's point out, actually, can we zoom in a little bit, Ms. Gussie? One more out. Okay. So first of all, you're able to draw on the screen in front of you, so can you circle on there where Beer Snobs is that we just talked about?
I can just circle right away. I don't need
Yep.
to touch anything else.
Okay, and that's kind of in the bottom left corner of the map.
Yeah.
And Height Drive, where you said that street was closed down, where is that? Maybe just draw a line.
Probably about there, give or take.
Okay, so where you drew that line, is that how far the street was closed down?
It was closed from Cottonwood or West Capitol to Goodwin because the stage was right in the middle of the street.
Okay, and what about Tabby's Wine Bar? Where is that? Can you circle that on the map? And back in June of 2023, where was Hometown Pharmacy?
Right down.
Okay, so we have Tabby's Wine Bar, and then directly west and next to is where Hometown Pharmacy was.
Correct.
So if somebody was at Beer Snobs at this concert, what are the different ways they can get to Tabby's Lake Country?
So there's a few different ways. They could either go from that corner of Cottonwood and Haight Drive and then walk up West Capitol to East Capitol and then just cut across on the front side. They can cut through between the building with 110 on it.
You can, if you want to draw a line,
Okay.
how you can get there?
So they can cut through from Haight up through here and then go down the sidewalk to Tabby's. Or they could come here off this road. There's kind of like a parking lot back there. And then access to the back side of Tabby's and the patio. Or they could go around like on Haight Drive and Goodwin, go up Goodwin, go north on Goodwin, and then west on East Capitol.
A lot of different ways, back way, side way, every way you can think of, right?
Correct.
Okay, so let me bring up another map just for you.
Just a minute.
Oh, actually, can we take a screenshot of this?
Request to preserve, this be Exhibit 1A.
Yes, Your Honor.
Any objection?
No.
Exhibit 1A will be preserved. All right, counsel.
And we can take that down now.
All right. Turn the publication off. Thank you.
I'm gonna bring up with you, exhibit number 2. And that should be on your screen soon.
We just have a little delay. There it is, it's up.
Yep,
Okay, Officer Martins, do you recognize exhibit 2?
I do.
And what is exhibit 2?
So that's a street view from East Capitol Drive to the front side of Tabby's and where the old Hometown Pharmacy used to be.
And this is 11 East Capitol Drive in the village of Heartland, Waukesha County, Wisconsin?
Correct.
Okay. And that's fair and accurate depiction of it?
Yes.
Request to publish exhibit 2.
Moving its submission.
Moving and then requesting to publish.
Any objection?
No.
Exhibit 2 will be received. You may publish.
Looks like the jury is staring at something, so I assume it's on their screen. And so, first of all, which one of these buildings that we see here is Tabby's?
This one here.
Okay, so it has black and white awning stripes.
Yep.
Okay. In the front there, are there any stools and tables?
Yeah, on the sidewalk there's stools and tables.
And right directly next door in a building that looks like it's connecting to it, what is that? At least
That's-
back in June of 2023, what was that?
That's the Hometown Pharmacy.
And can you draw a circle around there? Okay. And I would request to preserve and mark as Exhibit 2A.
Any objection?
No.
2A will be preserved and received. Next question.
Thank you. Now I'm going to ask that the publication come down. I'm going to show you exhibit number 3. Okay, do you recognize exhibit number 3?
I do.
And what is that?
It's the back side of Tabby's, so your view from Haight Drive.
Is that a fair and accurate depiction of
Yes.
the back of Tabby's and from Haight Drive?
Yes.
Okay. I would move exhibit number 3 into evidence and request to publish.
Any objection?
No.
3 will be received. You may publish.
Okay, and just on here, can you circle, actually, can we go one zoom in, Ms. Gussie? Okay. So, I see that there's like a purple sign. Do you know what that says?
Yeah, that's a sign for Tabby's. It's on their back balcony.
And is this one of the ways you can get into Tabby's Wine Bar?
Yes.
And that's kind of the back way that you described previously on the map.
Correct.
And then next door, that building that looks like it's connected to it, what is that, the back of?
The hometown pharmacy.
Okay. And again, is there, for Tabby's Wine Bar, there's a door back there, right?
I believe it's covered by this tree right.
Okay, so you have a pink arrow, but kind of difficult to see, but
I didn't mean to do that.
that's
Sorry
okay.
about that.
I would just ask to preserve Exhibit 3 as it is and make it 3A.
Any objection?
No.
3A will be preserved and received. Next question.
Okay. And now we can take that publication down. I'm now going to show you Exhibit 4. And do you see Exhibit 4 on your screen?
I do.
And what is Exhibit 4?
Well, that's the front side of Tabby's from East Capitol Drive.
And was this picture taken the night of June 17th of 2023?
Yes,
That's a fair and accurate depiction, is that true?
correct.
I'd move Exhibit 4 into evidence, Your Honor.
How many more photographs of this area do you have to go through?
After this one, too.
Do you want to just have him identify the next two exhibits? And
Sure. Sure.
that might expedite it.
Exhibit number 5, if you can bring up. Okay, and you see Exhibit 5 on your screen?
I do.
And what is that?
That's another view of Tabby's. It's from the east side, I guess, east view, showing the sidewalk in front of the building.
Okay, and Hometown Pharmacy would be in the back of this photo, right?
Correct. You can see the back, like, corner of it.
Was this photo also taken the night of June 17th, 2023?
It was.
Actually, is your squad car in this photo as well?
This is my lieutenant's squad car.
Okay.
Yeah,
That's a fair and accurate picture.
it is.
Okay, and lastly, I'm going to show you Exhibit 6.
That's the view from the west, looking east. It's the front side with the sidewalk and the bar stools and tables as well.
So now, from taking this photo, this is from taking it almost in front of Hometown Pharmacy and looking towards Tabby's.
Correct.
And that's also a fair and accurate picture?
Yes.
Move Exhibits 4, 5, and 6 into evidence and request to publish.
Any objection?
No.
Exhibits 4, 5, and 6 will be received. You may publish.
Start with Exhibit 4. So, like you said, this is Tabby's Wine Bar. And again, out in front, it looks like there's stools and tables. Is that right?
Correct.
Okay. And can you just circle those on here? So there's several. And those were there that night when you arrived on scene?
They were.
Okay. I would request to preserve 4A and move into evidence.
Any objection?
No.
4A will be preserved and received. Next question.
Okay, Exhibit 5. And again, we see Tabby Wine Bar, and then in the back would be Hometown Pharmacy where we can see more lights.
Yep.
Is that right?
Yes, correct.
Okay. Tabby's looks pretty dark. Is that how it looks in here?
Yes.
And then the lights that we're seeing, those are street lights and maybe coming from Hometown Pharmacy.
Correct.
And Exhibit 6. And this is just from the other side of Tabby's as if we were standing in front of Hometown Pharmacy. Is that right?
Correct.
We can take those down. So around 11 p.m., you were on routine patrol in your squad car, is that right?
I was.
Okay. Around 11 p.m., did you get flagged down by a group of people in front of Tabby's Wine Bar?
Yes.
And tell me, what did you see?
So I was traveling north on West Capitol Drive at that intersection of West Capitol Drive and East Capitol Drive. When I stopped at the intersection there, I turned to check for traffic on East Capitol Drive and saw a fairly large group of people waving their arms in an attempt to flag me down. So I advised my dispatch of the situation and drove over in that direction.
Okay. And what did you observe when you drove over by that group of people?
When I drove over there, I immediately got out of my squad car because obviously something was going on. When I exited my squad car, there was, like I said, a fairly decent-sized crowd. And I had people telling me that something just happened, some guy just got hit. I have information coming from a lot of people.
Judge, excuse me, I'm going to object to him testifying to what people told him.
On grounds?
Hearsay.
Sustained.
What did you see? That's what I want to know.
Judge, I move to strike that portion of his answer. That you object, whose objection you granted.
I sustain the objection, and the record will stand. Next question.
What did you see around this group of people?
I saw the victim laying on his back. He was not moving. I saw that he was breathing, and I saw a male and female standing or crouched down next to him, tending to him at that time.
Who is the male laying down on the sidewalk identified as?
Joshua Davies.
Okay. And you said that there were two people surrounding him. Who were those two people?
They were later identified. The female was identified as Jennifer Davies, and the male was identified as Brian.
Brian Richardson?
Yes.
Okay.
One of their friends.
And once you saw this, you took, not asking what they said, but did you gather some initial information from these witnesses?
I did.
Okay, and what did you do next?
I advised our dispatch of what had just occurred. I notified them that there was a fight, that the victim got punched in the face by an estranged man.
Just a minute. When he objects, is there an objection, sir?
Yes.
So say the word objection.
Objection, hearsay.
Thank you.
It's foundational, Your Honor. It's not hearsay, it's not being used.
Offered for the truth.
Right, it's just to say what he did next, so
Thank you.
people can understand.
Court is going to allow the characterization for purposes of foundation. I'll overrule the objection. Witness can continue the answer. Do you recall the question?
Can you just give me the question one more time?
Okay, so you saw people lying on the ground, and what did you do next?
So I advised our dispatch that there was a fight that just occurred, and that a male had fallen to the ground due to being punched in the face, caused him to go unconscious, and then I had additional units respond to the scene because I had seen and heard that the suspect was no longer on scene, and we needed to attempt to locate him.
And from these witnesses, did you get a description of the suspect?
I did.
Okay. And what was the description?
The description was a male white, approximately 60 years of age, glasses, heavier set, wearing a white and blue striped shirt and jeans.
And did you relay that information to dispatch?
I did.
Okay. Now, did you remain on scene by Mr. Davies at this time?
At this time, yes.
Did any other officers do anything else that you're aware of?
My patrol lieutenant, Conrad Saboniak, he arrived on scene. The information was relayed to him from myself and another witness, and then he went and checked the area for the suspect.
And then did you go and focus more on Mr. Davies and Jen Davies and Brian Richardson?
I did.
Now, during this time, while you're calling for your lieutenant to go look, you're calling in dispatch, did you ever see Mr. Davies get off the ground?
No.
Okay. Did you go over by Mr. Davies?
I did.
And did you try to talk to Mr. Davies?
I did.
Can you tell me what you observed Mr. Davies to look like at this point?
At this point, I went over by him. I asked, tried to see if the people identified as Jennifer and Brian were comfortable staying by him. I observed that his eyes were closed, but he would open his eyes every once in a while. His body movements were minimal, and I did see that he was breathing. I attempted to ask if he could hear me. I couldn't get a verbal response from him, but I did see him attempt to open his eyes. and then I tried a sternum rub, which is an attempt to, have somebody react to the pain, and his body didn't react, but once again, his eyes did open.
And for a sternum rub, can you kind of demonstrate what you're doing on yourself maybe?
Yeah, so you're like taking your knuckles and you're just rubbing on the sternum up and down like this. And like I said, that's supposed to make somebody react to the pain, because it does cause a little bit of pain.
And how did Mr. Davies react when you did that?
He just opened his eyes. He didn't verbally say anything or like try to move my hand off of him. He just tried to open his eyes.
Now, you said that, were you ever able to talk to Mr. Davies?
No,
Okay. Did you ever get a statement from Mr. Davies?
I did not.
You said that Jennifer Davies, his wife, was around him. Is that true?
Yes.
What was her emotional state?
She was frantic. You could tell she was in distress. I mean, rightfully so. There's really no words for it. She reacted how anybody should in that situation.
And while she's in this emotional state, did she say anything about what occurred?
She said that he got punched in the face and he fell down. The punch caused him to go unconscious, which made him fall to the ground.
Counsel approach. Behind. Objections overruled. The testimony will stand. Next question, please.
Did you call for any ambulance or EMS to arrive to the scene?
I did.
And was that for Mr. Davies?
Yes.
And eventually, they arrived on scene. Did they take Mr. Davies away in the ambulance?
They did.
Okay. During this time, did you ever personally go and look for the suspect in this case?
Yes.
And where did you go to look for the suspect?
I went through the building. Well, I looked inside of the bar first, inside of Tabby's, to make sure he wasn't still in there. Nobody didn't say anything. And then I went around the buildings through Snobs Fest, which was that festival that I talked about earlier. I went all the way down Haight Drive and could not locate the suspect.
Okay. And you had your squad car there?
I did.
Was your squad car equipped with squad video?
Yes.
And did it at least capture this initial scene that you had arrived at?
Yes.
Ms. Gussie, if you could please bring up exhibit number 7. Okay, Officer Martins, do you see on your screen exhibit number 7, which is a squad video?
I do.
And does this look like it's from your squad, Squad 3, the night of June 17th of 2023?
Yes.
And that looks like a fair and accurate depiction of it?
Yes.
And have you reviewed your squad video before coming here today?
I have.
Okay. And I'm going to move exhibit number 7 into evidence. I don't plan to play it with sound, Your Honor. But it will just be a short clip of the scene.
Any objection?
No.
Exhibit 7 will be received,
And just to confirm with Ms. Gussie, the sound is off.
and you're asking for it to publish?
I'm asking to publish, Your Honor.
Any objection to that?
No.
You may publish.
Okay, and I'm gonna start, or I'm gonna wait. Okay, I'm gonna start exhibit 7. Actually, Ms. Gussie, can you go back? It's at 01. And prior to us playing this, Officer Martins, do you see yourself in this video?
I do. I'm on the sidewalk.
It says police on the back, is that you?
Correct.
Okay, and where's Mr. Davies?
Well, where I'm first standing here, you can see his feet pointing towards me. His head's kind of towards the corner of Hometown Pharmacy and Tabby's.
Okay, and looks like somebody's crouching next to him. Who is that?
That's Jennifer.
There's a guy in a white shirt standing by that pole. Do you know who that is?
I do not.
Okay. Can you kind of see Brian?
Yeah, you can see the corner of his red shirt and his foot in this picture.
Okay. And if we could just start playing. Going to stop it for 1 second, and we stopped it at 45 seconds. I see somebody in a car in front of you that just opened the trunk. Do you know who that is?
That was a musician that was playing inside of Tabby's that night.
Okay. And we can continue at 45 seconds. I'm going to stop it at 1 minute and 50 seconds. Are you talking to another squad car? Another person in another squad car?
That is my lieutenant, Conrad Saboniak.
So are you relaying, what are you talking?
I relayed the information that I gathered so far, along with the suspect description, so he could go try to attempt to locate the suspect.
Okay, and continue playing at 1 minute and 50 seconds. that's the end. It was a total of 2 minutes and 36 seconds, and that was a fair and accurate depiction from that night.
Yes.
We saw that you were talking to two women who had kind of followed you to your lieutenant's squad car. Who were those women?
They're both bartenders inside of Tabby's that night.
And they gave you a description of the suspect?
Yes.
After the scene had calmed down and the ambulance took Josh away, where did you go?
I ended up following the ambulance to Summit Hospital.
Aurora Summit Hospital?
Huh?
Aurora Summit
Yes.
Hospital? Okay. And did you stay at the hospital?
I did.
Did you also get a written statement from Jennifer Davies at that time?
I did.
While at the hospital, were you ever able to speak with Josh Davies?
No,
Were you ever able to get a written statement from Josh Davies?
I was not.
Did you see Josh Davies at the hospital?
I did.
Was he awake?
No.
I don't have any further questions, Your Honor.
Cross.
Judge, could we be heard at sidebar for a minute?
Yes. All right, Mr. Sherrill.
Thank you, Judge. So you've been in law enforcement for a couple of years, it seemed like?
Yes.
And you finished your schooling back in '22, is that right?
December of 22, correct?
Okay. And I presume you've had some training since you became a law enforcement officer?
Yes.
Then you received training while you were studying to become a police officer, correct?
Correct.
And one of the things that you are trained to do is prepare reports regarding interviews, is that true?
Correct.
Okay. And it's my understanding that you prepared a report in conjunction with the investigation, is that right?
Yes.
Have you seen it?
Yes.
Okay. So I'm going to look at a portion of it. And where you indicate that you received a written statement from Mrs. Davies. You did that, right?
Correct.
And in fact, you actually, it seems to me, typed out what she wrote in her handwritten statement. Is that correct?
Correct.
And they're basically word for word. Do you agree?
Yeah. Yes.
So, and you would agree that in neither her handwritten statement nor your recitation of it in the report, does she say that Mr. Sehmer punched her husband? Isn't that true?
I don't recall what was exactly in my report.
I can show it to you.
Okay.
Page 8. Want me to vote?
You may.
Do you see this? Take a moment to look at it. Am I right?
Correct.
So in her statement, she doesn't say, either in her written statement or your typed version of it, that she saw Mr. Sehmer strike her, punch her husband in the face. True?
Correct.
And she had both an opportunity to talk to you and to write out the statement, correct?
Correct.
And that was, I think, that night?
Yes.
Okay. All right. And I saw in the squad video that it appeared that Mr. Davies' feet were to the west of his head. Am I right?
Yes.
So his feet were closer to hometown as opposed to the entrance of Tabby's, correct?
Correct.
All right. Now, I presume that in your law enforcement experience, you've had to deal with people who have had too much to drink,
A few times.
okay? You made any arrests for drunken driving, for example?
Yes.
How many times?
An objective relevance.
Overruled, it's foundational.
On the road,
Anywhere?
approximately 30.
Okay. So on approximately 30 times, and I'm not holding you to this, on approximately 30 times you've had occasion where you were taking law enforcement action to determine whether a person may have had too much to drink, correct?
Yes.
And I presume that because you've made stops and perhaps arrests for drunken driving, you had opportunities to try to determine the condition of a person, that is, have they had too much to drink, correct?
Through standardized tests. Correct.
Right. And those tests, those standardized field sobriety tests, include tests which says that persons who have too much to drink have difficulty having good coordination. Would you agree?
Yes.
That's pretty normal, correct?
Yes.
And while you're not a physician, your experience would tell you that persons who have a really high BAC are going to have even more pronounced inability to exercise coordination, correct?
Correct.
All right. I have nothing further, but thank you.
Any redirect?
We just talked about how you would do field sobriety tests on somebody who was intoxicated. Were you able to do any field sobriety tests on Josh that night?
No,
Why not?
because he was unconscious and unresponsive.
And the suspect, if you learned that he was intoxicated, would you have done field sobriety tests on him potentially?
Judge, I'm going to object, it's irrelevant.
Overruled.
If he was driving and I had reason to believe that he was impaired, I would perform the test.
Okay. And now, Mr. Shiro showed you part of your police report. I think it was page 2, and it described Ms. Davies' written statement.
Yes.
And he asked you if anything on page 2 said that she said the male party had punched Josh, right? That's his line of questioning.
Yes.
I'm going to show you the first page of your report.
No. also, that's what it says. I don't need that. I know what he wrote.
Ladies and gentlemen, I'm going to ask you to retire to the jury room, take a break. We're at 3 o'clock. It's a good point to stretch your legs. I'll have you back here in a few minutes. Please do not discuss this case.
All rise.
Court will stand in recess 10 minutes.
John, I can show you, that's what she says. I can show you what he's talking about.
I can read the report, and it says Jennifer
Couple of things for the record. There was a question that was asked of the officer soliciting information offered through a witness that was represented to be the spouse of the victim. The question was, did she tell you, or what did she tell you, meaning the spouse of the victim? The witness, the officer, answered, among other things, that the defendant punched her husband in the face. There was objection based on hearsay. The court held a sidebar. I informed counsel that I felt the objection was tardy, that the question had been posed soliciting the information. It wasn't until the information was offered that it was objected to. Based upon that, I overruled the objection. I held it at sidebar because we have a difficulty currently with the fact that the jury is being housed when they're not in the courtroom, not on this floor. And so I'm trying to minimize the amount of movement that occurs for this jury because it involves some involved process and delay, which is why I chose to do sidebar, informed the parties of what I was going to decide, because I did not want to have argument in front of the jury as to the substance. So when I released the parties back to their place, I indicated the objection was overruled and I asked them to move forward. I also had instructed the state at that I felt they were asking for information that could be substantively hearsay. They had my impression at the sidebar complaint about that they felt they could meet a burden regarding excited utterance. I informed the state that these issues could have been dealt with in pretrial. They were not raised. I'm not going to deal with them in that fashion here. So that was the decision that I made. That's the record I'm making regarding that decision. Are we ready to proceed?
I would note that there is disagreement about what the state can show Officer Martins on the stand. So the line of questioning was, Mr. Shiro showed Mr. Martins his report saying, this is word for word the written statement Ms. Davies gave you. Nowhere in here does it say in your report that Ms. Davies said Josh was punched in the face. The state's contention is that in order to rehabilitate Officer Martins, because it is in his report on page 1, and I can bring it up for the court to show you, his report says, Jennifer, Ms. Davies, recognized the witness that was there and said to her, that guy, your friend, just hit him in the fucking face. That's also in his report. And it's quoted, or that guy, your friend, just hit him in the fucking face. That's a quote. Now, Mr. Shiro disagrees that that was a statement that Ms. Davies made. He thinks it's a statement the witness made. I have a squad video that shows that was a statement Ms. Davies made. I believe that the state can rehabilitate Officer Martins and show him that part, since the defense brought it up that his report did not contain a statement from Ms. Davies, that her saying.
I understand the state's position. Mr. Shiro.
Judge, I object. First of all, we don't really have a context other than that, I'm sorry. She, being Ms. Davies, is talking to some other person. We don't know who. I understand that the state contends that that would be.
Stop it. I'm going to tell both of you right now. Despite the representation that you're all going to get along, you're bickering like school children. And that is not happening in my courtroom. So you're going to limit that, particularly when this jury is here, or I will call both of you up short. Am I clear?
Yes.
Am I clear?
Yes, sir.
Continue with your argument.
Thank you. So I don't think it's a rehabilitation. What I had asked the officer about was his report regarding Ms. Davies' statement. And he read it, and he didn't remember it, so I let him read it, and he said, yes, she doesn't say that in that statement. I don't think calling in further hearsay is somehow is allowed, because I asked the officer about his report regarding the statement that he obtained from Ms. Davies.
This all stems from the objection that I deem to be tardy.
Right.
And the information is in the record. You attempted to impeach him based upon that information. You opened the door as to the police report. State has a right to try to use it to rehabilitate. If you feel it isn't relevant or isn't her statement, those are questions you can ask this witness in further cross-examination. But for purposes of today, the court's going to allow the question to be asked because the report has been discussed regarding refreshing this witness's recollection as to what was in his report. I recognize you said in his written statement, but you used the report as the basis for refreshing his recollection regarding that written statement. I think it opens the doors to that report and the usability of it, and the hearsay aspect of it, it was already dealt with by me. So whatever objection you're interposing here is overruled. The state can use it. Is there anything else that the state feels I need to address before I bring the jury back?
No, Your Honor.
Defense?
No.
Thank you. Would you get him, whoever's calling? Is it bailiff? Thank you.
All rise.
Please be seated. All right, ladies and gentlemen, we're continuing with the trial. We're redirect of this witness, Ms. Zillaviv.
Officer Martins, Attorney Shiro just showed you a copy of your police report, is that right?
Right.
And the police report you did in this case was 2 pages long?
Correct.
And he showed you the second page, is that right?
Right.
Okay. Now, he asked you questions about if Ms. Davies ever said Mr. Davies got punched in the face, right? That was the question?
Correct.
Okay, I'm gonna show you both pages of your report, and I'm gonna point to where I wanna direct your attention. I'm gonna have you read that, not out loud, and then I'm gonna take the report back from you, okay?
Okay.
Officer Martins, does that refresh your recollection on whether you wrote in your report, whether Ms. Davies said her husband Josh was punched in the face?
It does.
And what did your report say?
Miss Davies stated that to another witness, she recognized the witness that was there, and said, that guy, this is in quotes, that guy, your friend, just punched him in the fucking face, end quote.
Now, when you got the written statement from Ms. Davies, where was she?
The written statement?
Yes.
In the hospital.
With her husband?
Yes.
About how long after this incident occurred did you get the written statement from her?
Probably a couple hours after.
Was Ms. Davies at the hospital that entire time?
Yes.
I have nothing further.
Any redirect on that limited scope?
No,
I'm sorry, recross on that limited
no,
scope.
no, thank you.
Thank you. May this witness be released?
Yes.
Any objection?
No.
All right, officer, you can step down, go about the rest of your day. State have its next witness.
Yes, the state would call Officer Luke Jozwick.
Officer, would you come forward, please? If you go to the jury witness box behind the court reporter. Step up there, raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God? I do. Have a seat. Direct your voice to that black bar with the red light and keep your voice up. Counsel, your witness.
Thank you, sir. Please state your name and spell it for the record.
My name is Luke Jozwick, Luke L-U-K-E, Jozwick J-O-S-W-I-C-K.
How are you employed, sir?
I'm employed by the Village of Heartland as a police officer.
How long have you worked in law enforcement?
Total about 13 and a half years.
All with the Village of Heartland?
9 and a half with the Village of Heartland.
All right. And you still work there today?
That's correct.
Okay. Directing your attention to the morning of June 18th of 2023, did you work for the Heartland Police Department that morning?
I did.
What time did you start your shift?
I start my shift at 6 a.m.
And when you came on duty, were you asked to assist in an investigation that had carried over from the night before?
I was.
And what were you specifically asked to do?
I was asked to look for camera footage from Hometown Pharmacy on East Capitol Drive.
Okay. And you were aware that there had been a report of an incident at Tabby's Bar, correct?
That's correct.
Okay. And so someone asked you to go to the pharmacy and see if they had any video?
That's correct.
Okay. Did you do that?
I did.
And did you meet with anybody at the pharmacy?
Eventually, I contacted him by phone, the owner by phone first because they weren't open, and he said that he would check the footage and see if there was anything there, and he called me and said that there was something, and so he wanted me to respond over.
Okay. And when you got there, were you able to observe whether or not there are any video cameras inside the pharmacy?
I was.
And could you describe for the jury where the camera was located?
The camera's a little bit back away from the front door, but it's facing the front door on East Capitol Drive.
And do you know where it was mounted?
It's mounted on the ceiling, approximately like 10 or 15 feet back from the window.
Okay. And were there any other surveillance cameras at that pharmacy?
There are, but none that would point in that direction.
Anything that would capture that front sidewalk area?
Only that front-facing one from inside the building.
Okay. Did you have an opportunity to view the video that the pharmacist showed you?
I did.
And did you believe that it contained information relevant to this investigation?
I did.
I'm going to ask Ms. Gussie to put up number 8, please, for the witness only.
All right, it's in the witness box.
Thank you. Sir, do you recognize, this is a still shot of a video, correct?
That's correct.
Do you recognize what we're viewing here?
I do recognize that.
How do you recognize it?
This is the video camera that I was looking at that morning with the pharmacist at Hometown Pharmacy.
And you've seen this recording before your testimony?
I have.
Do you believe it's a true and accurate representation of the events that evening?
I do.
Move for admission to number 8 and permission to publish, Your Honor.
Any objection?
No.
It'll be received. You may publish.
Okay, Officer Jozwick, could you please orient the jury to what we're looking at here?
Again, this is the camera mounted on the ceiling facing north or towards East Capitol Drive inside the hometown pharmacy.
So that large object in the center of the screen is the front door to the pharmacy?
That is correct. That's the front door.
Okay, and on the sides of the doors, what's contained on the sides?
There's some windows on the sides of the door, and there's, I guess, general knickknacks that you would see at a pharmacy for sale.
Okay, like merchandise?
Yes.
Okay, and it appeared from this video that the pharmacy keeps their interior pretty well lit. Is that consistent with your experience?
That's correct.
And outside, is there any lighting outside the pharmacy, to your recollection?
There are some street lights, but I'm not sure where they would be located exactly.
Okay. And you understood that your department was investigating what was reported as a battery, correct?
That's correct.
And when you viewed the video, did you see anything that would be, again, consistent with what had been reported?
Yes, I did.
And I just want you to help the jury. We're going to play this video here in a minute, but before we do that, tell the jury what to look for, please.
Okay.
You can point, yes, a touch screen, so if you actually touch the screen, I think an arrow will pop up, but you can circle or draw lines or whatever is easiest for you.
The area of focus would be in this area, and things will move from right to left on the screen. That would be the area to look at.
And will you see people?
You will see 2 individuals.
And can you see any objects in this video? With the people?
Yes, I can see one object.
Okay. And Tabby's bar is in which direction?
Tabby's bar would be on the right side over this way.
Okay. I'm sorry, could you see any objects being held by any of the people in the video?
Yes, I can.
And what was that object?
It's a stool.
Okay. First, I'm going to ask the court to please preserve Exhibit 8A.
Any objection?
No.
8A will be preserved and received.
Okay. And then clear the screen, please, once that's done. Your Honor, this video is 22 seconds long. With the court's approval, I'm going to play it through once and then go back and have Officer Jozwick describe what was seen in the video to kind of break it down, instead of stopping and starting, stopping and starting.
Any objection?
Judge, I think we've agreed, I thought we had agreed that, the parties had agreed that we're not going to let witnesses say what the video shows. That's for the jury to see. I don't object to the state asking if they think they see something, but
Right.
they
No,
can see the
I
same thing.
totally agree with that.
All right. So your general description, playing it through once and then asking questions is not objected to and acceptable to me, so you can proceed to do that.
Thank you. All right. For the record, it's played through once in its entirety without any questions. And I'm going to ask Ms. Gussie to now back up and start it again, and then I will ask her to pause it as we go through. Stop. Maybe a little too quick, I know. Trigger finger. Stop. Okay. Can you see any people in the screen at this time?
I can see one person in the screen right now.
And did you later learn the name of this person?
I did.
And what is the name of this person?
The person in the screen right now is Joshua Davies.
Okay. And can you see any other people on the screen right now?
Not right now.
Earlier, could you see a person?
I could.
We oriented us to the time on the video.
Thank you, sir. It's 14 seconds. We paused at 14 seconds. Did you later learn the identity of the second person that was in the video?
I did.
And what name did you learn that person to be?
Kevin Sehmer.
Okay. Do you see Mr. Sehmer in the screenshot at this moment?
I cannot see him at this moment.
Okay. Can you see Mr. Davies?
I can.
Can you circle where he's located, please? And I'm going to ask the court to please preserve 8B.
Any objection?
No.
8B will be preserved and received.
Thank you. And now we'll continue to play. All the way through the end. Officer Jozwick, you reported in your report that you could see a stool, and I think you just told this jury that you could see a stool in this video, correct?
That's correct.
Can you see it in this video?
If you look, can I touch the screen?
Well, yes.
Okay. If you look in this area, when Officer Martin's squad car arrives shortly after this, you can definitely see the stool with the lighting there. You can kind of just see it for a second. I've watched it many times, like on repeat, so.
So it's at a later point in this video?
Yes.
That you see that?
Yeah.
In the clip you just watched, were you able to see the stool?
Not right now.
Okay. So your testimony is that in a clip that's not in this portion, or I'm sorry, a recording that's not in this clip, you can see the stool?
That's correct. When the squad car lights illuminate it.
Okay. And where did you see the stool in that clip?
It's right next to Joshua's, where he's laying.
Okay. All right, I'm going to look for that portion of the recording that you just referred to, but while they do that, I just want to ask you a separate question.
Can we clear the screen?
Yeah, you can clear that screen.
Thank
Thank
you.
you,
Go
sir.
ahead.
Did you or other members of the Hartland Police Department attempt to obtain video from all the other businesses around the area?
We did.
Was this the best we could come up with?
It is.
Okay. As far as outside of Tabby's, correct?
That's correct.
And you're aware that there was video recovered from inside of Tabby's?
Yeah, I am aware of that.
Okay. Later in the day, on June 18th of 2023, did you have personal contact with Kevin Sehmer?
I did.
Were you able to observe his appearance
I was.
and his approximate size?
I was.
In your opinion, what is the height of Kevin Sehmer?
I would guess approximately 6'1".
And do you have an estimate as to his weight?
I would guess around 250 pounds.
All right, those are all my questions. Thank you.
Cross.
I don't have any questions, thank you.
Thank you. May this witness be released?
Yes.
Any objection?
No objection.
Thank you, officer. You can step down, go back the rest of your day, sir.
Thank you.
State have another witness?
Yes, the state calls James Armstrong.
All right.
Okay. No, it's okay. I've got it somehow. I'll probably, as long as I know what the number is, I can do it.
Mr. Armstrong, would you come forward, please? Come to the witness stand, which is behind the court reporter, please. You want to set your material down? Just step up on that rise and raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, have a seat. There's a black bar with a red light. Keep your voice directed there and your voice up. Counsel, your witness.
Thank you. Mr. Armstrong, can you please state your name for the record?
James Armstrong, A-R-M-S-T-R-O-N-G.
And how are you employed?
I'm a forensic imaging specialist with the Wisconsin State Crime Lab.
And what are your responsibilities as a forensic imaging specialist with the crime lab?
My responsibilities include photographing evidence for lane prints, footwear, and in addition to that, also forensic video analysis.
And you're at the crime lab in Milwaukee, Wisconsin, is that right?
That is correct.
And there's 2 other crime labs in the state of Wisconsin, in Madison and Wausau, right?
That is correct.
And prior to court today, did you provide a statement of your qualifications?
I did.
Okay, I'm going to show you Exhibit 9. I'm just going to show a paper copy. I have a copy for your honor if you would like it.
Have you provided defense?
Yes.
All right, thank you. I don't need it.
Thank you. Okay, Mr. Armstrong, I'm showing you Exhibit 9. What is that?
This is my statement of qualifications.
How many pages is it?
3 pages.
And is that a fair and accurate copy of your statement of qualifications?
It is.
So I want to go through this a little bit more in depth. First of all, can you tell the jury about your educational background?
I have a bachelor's in photography from Milwaukee Institute of Art and Design.
And when did you receive that degree?
2002,
And what was your major?
in photography.
Sorry, you already said that. And I want to talk now about your professional experience. Can you tell the jury about your professional experience?
My professional experience includes working in commercial photography for 14 years, both as an in-house or staff photographer, along with being a freelance photographer.
And after you were, during freelance photography and working as a photographer, what kind of photographs would you do?
Typically, it would be mostly product photography, so shirts, hats, scale models, those types of items.
Okay, and did you transition into a different type of photography after that?
Yes, I was, after that time period, I was then hired by the State Crime Lab.
So when were you hired by the State Crime Lab?
I was hired in, in 2015
And what was your first position at the State Crime Lab?
as a forensic imaging specialist.
Okay. And so you've always been a forensic imaging specialist since 2015 at the Crime Lab?
Yes.
Did you have any other titles or duties at the Crime Lab in addition to forensic imaging specialist?
Yes, I'm also a member of the crime scene response team as a photographer and a team lead.
And what did you do as a crime scene response team leader and photographer?
Our job as a crime scene response team lead and photographer is to help requesting agencies process crime scenes.
Now I want to talk about your training as it relates to more forensic photography that you're now doing at the State Crime Lab. So first of all, where did you receive training for your position at the Crime Lab?
So for our position, we receive training both internally and externally. Internally, we have approximately one year training program focused on forensic imaging. And then externally, we receive training through it's called LEVA. It is an organization that provides forensic video analysis training, along with training through the software I use called AMP5.
And AMP5, just for the record, is spelled AMPED space FIVE, and FIVE is all capitalized.
That is correct.
Okay. And you said LEVA, again, what is LEVA?
LEVA is Law Enforcement and Emergency Services Video Association International.
And on page 2 of Exhibit 9, it actually details in depth your training at the crime lab in order to be a forensic imaging specialist. Is that true?
That is correct.
So your training for AMP5, what did you do in order for that training?
For that training is a training provided by the manufacturer, both for different modules of the software, along with a approximately 4-day course on the software itself.
And what is AMP5?
AMP5 is a forensic image and video enhancement program.
And are you certified in order to use the software program AMP5?
Yes, I've earned a certification from the manufacturer in the use of that software.
And AMP5 is that's something that is also used in the forensic imaging community routinely?
Yes.
And is it a software program that is reliable and accurate for the purpose of forensic imaging?
Yes.
And LEVA, again, what types of trainings did you do with that?
LEVA provides a 4-level training program. To advance to the next level, you need to complete an oral, written, and practical exam in order to be able to move forward to the next level. I've completed all 4 levels of training they offer.
And is LEVA, I guess, for all forensic imaging specialists all around the country?
Yes, it's an international organization that they provide training for people working within that field.
And is that organization something that is respected and relied on in the forensic imaging community?
Yes.
And do you have any professional affiliations that you're associated with?
Yes, I'm a member of LEVA, along with the IAI, the International Association of Identification.
And when did you become a member of LEVA?
I became a member of LEVA in 2017.
And are you still a member today?
Yes.
And the other membership that you talked about, how long have you been part of that?
I'm part of the IAI since 2019.
And have you ever testified as an expert in the category of forensic video analysis?
Yes, 4 times.
All in the state of Wisconsin, I presume?
Yes, all in the state of Wisconsin.
Now, did you get a forensic imaging request involving, the 2 people involved were Josh Davies and Kevin Sehmer?
Yes.
And when that case came to you, was it ultimately assigned lab case number R23-1921?
Yes.
Okay. And kind of jumping ahead, but did you generate a report and review some videos and enhance them for this case?
Yes.
And the report you generated, you also provided that as well?
Yes, I did.
Okay. I'm going to show you Exhibit 10. And what is Exhibit 10?
Exhibit 10 is my report issued for this request.
And again, that's for R23-1921.
That is correct.
And is that a fair and accurate copy of your report?
It is.
And it's 2 pages, to be clear?
It is 2 pages.
I would move Exhibits 9 and 10 into evidence, Your Honor. I don't intend to publish them at this time.
Any objection?
No.
9 and 10 will be received.
So let's first start, at least from this report, what evidence did you receive for this case?
I received digital file. I received digital files submitted electronically to the crime lab.
And first, let's talk about the first video. That would be, or actually the second video. Second video I'm going to talk about first. That was labeled tabbies. Does that sound familiar?
Yes, it does.
And what kind of file was this?
This was a video file that I was requested to provide audio increase to it.
Only requested to enhance audio on this one.
Just the request simply was just to increase the volume of that video file.
Okay, so can you tell the jury how you do that?
We take the video file into Adobe Premiere and we increase the volume of that video file.
Okay, and Adobe Premiere, is this something you've been trained to use?
I have experience in using it, yes.
And is that program reliable and accurate in terms of the forensic imaging community?
It is used within the forensic imaging community.
And how exactly do you make the volume louder in Adobe Pro?
So in Adobe Premiere, what we do is utilize the effects panel, and we increase that volume by a level that we determine to be, that we want to have it be at.
Okay. Now, when you're increasing the volume, are you in any way changing the content of that audio?
No, we're not changing the content of the audio.
Okay. You did not enhance images on Tabby's video, is that true?
That is correct.
Okay. And now I'm going to bring up Exhibit 11.
The witness box. It's up. It's in the witness box.
Thank you.
And do you have a video up on your screen now?
I do, yes.
And I think Ms. Gussie can show what the title is if she moves her. Exhibit 11, do you see it's R23-1921. Another case number in Tabby's enhanced.
Correct.
Is this the video that you enhanced the audio on?
Yes.
And this was the video you then provided back to the police agency, is that true?
That is true.
And this looks like a fair and accurate copy of the video, is that right?
It does.
I would move Exhibit 11 into evidence, and I've consulted with defense, and we're just going to play the entire 4 minutes, Your Honor.
Any objection to the exhibit?
No.
Exhibit 11 will be received. You intend on publishing?
I do have a request to publish to the jury, and there is sound with it.
All right, any objection?
No.
You may publish.
And we're starting at 01, but we're playing the entire video. It's 4 minutes and 6 seconds.
Let's go. No. Well, then shut your fucking mouth. Steven, take that. Trying to be funny. Trying is a key word. Trying. That was the voice that you said. Please, just being a little girl. Little Karen. from non-pilot.
Maybe she's at
Don't take it personal. What did you say?
Okay. And the video is stopped. We can take that down now. And the next video that I want to talk about that's referenced in your report is hometown pharmacy video. Does that sound familiar?
Yes, it does.
Okay, so first of all, what kind of file format did you receive this hometown pharmacy video in?
I believe it was a .avr, which is a proprietary file format.
And with that file that you received, did you also receive the proprietary player?
I did, yes.
Okay. And what did you do to get the video out of the proprietary player?
I exported it as a .avi file.
And when you exported it into a .avi file, I guess generally, can you describe how you do that?
It was a function of the player itself, and we're essentially putting it in a wrapper so that the computer can understand how to play that video file back.
Okay. And when you exported the video from the proprietary player into the AVI file, did you change the content of that video in any way?
I did not.
And this video, the hometown pharmacy video, did it have sound?
I do not recall.
If I told you no, would that sound right?
I believe that would be correct.
Did you do anything with sound on the hometown pharmacy video?
I did not.
You only dealt with the video portion of it, is that right?
That is correct.
Okay, so after changing it into the AVI file, did you then enhance this video in certain ways?
I did.
Okay, so just generally, can you tell us the ways you enhanced it?
So for this particular request, we made the image, or we made the video brighter. We enlarged the video, and then we cropped in to the area of interest.
Were there any limitations on what you could do with this video file that's detailed in your report?
Yes, we have the lighting conditions. We have the reflections on the windows from the interior of where the camera is positioned. We have the distance between the person of interest and the camera. And again, the lighting conditions of that video file being bright on the inside and then dark on the outside.
Now, is it like CSI where you enhance a video and it's perfectly clear now?
No, making something bigger does not necessarily mean it's going to be clearer.
Okay. So if you had a blurry license plate from a traffic cam and you enhance it and on CSI it looks perfectly clear, is that how it really works in the world?
It does not.
Okay. So what software did you use in order to enhance the video the ways that you just described?
I use AMP5 for our processing of that video.
And that's the software you previously described that you were trained on in your testimony?
Yes.
Now, I think it might be easier to pull up the video so you can see which one I'm talking about first, and then I want to go through what you did with it. So I'm going to ask that Exhibit 12 be pulled up just on your screen?
The exhibit's there.
Thank you. And exhibit 12 is R23-1921 ACH01 enlarged 4 times. Is that right?
That is correct.
Okay. So what did you do with this video?
So for this video, we brightened the video to make it brighter, and then enlarged the video, and then cropped to the area of interest.
Okay. And on the screen, does that appear to be a fair and accurate depiction of the video that you enhanced in this case?
It is.
And I would move exhibit 12 into evidence and
Any
ask to
objection?
publish.
Any
No.
objection?
To either.
Exhibit 12 will be received. You may publish.
Okay, and Mr. Armstrong, this is a 15-second clip, correct?
Yes.
So I'm going to have it played for you and then maybe ask you a couple questions. And, okay, I'm now going to bring up exhibit number 13. I'm gonna ask to take down the publication. Gonna bring up exhibit number 13 and have it stop. Okay, exhibit 13 is R23-1921 CH01 enlarged 4 times, slowed by 50%. Is that what the title is?
That is correct.
Okay, so number one, how much was this video enhanced? Like how many times?
So this was, again, where we are brightening the video up. Then we are enlarging it, cropping it to the area of interest. And then for this particular video, we're slowing it down by 50%.
Did you do all of those things in amped 5?
Yes, I did.
And forgot to ask you this for exhibit 12, but did you change the content of exhibit 12 in any way?
I did not.
And again, for exhibit 13, slowed down, did you change the content of the video in any way?
I did not.
Okay. I would move exhibit number 13 into evidence and request it published to the jury.
Any objection?
No.
13 be received. You may publish.
Okay, and ask that it be played for the jury. Okay, and that clip was 30 seconds long, correct?
Yes.
Okay, because the original clip was 15 and you slowed it down by 50%, so times, it's now 30 seconds.
That is correct.
I'm gonna have the publication taken down to the jury. I'm gonna bring up exhibit number 14. Pause it. Now, exhibit number 14 is entitled R23-1921 ACH01 difference enlarged 4 times. So tell the jury what you did with this video.
So for this particular video, we take all the frames of the video and merge it into a single image. Then we take that same video and overlay it. This will allow us to see the motion of within that area of interest. In addition to that, we also make it brighter. We also enlarged it and then cropped it to the area of interest.
Now, when the jury sees this, to me it looks black. Is that right?
Yes.
On your screen it looks black.
Yes.
So again, can you describe why it's black?
So the reason why it's black is that it's called absolute difference within M5. What we're doing is that we're looking at the pixel values, and the areas that don't move are going to be black because there's no difference there. But the areas that do move, there will be, everything will kind of be a little bit of a different color just due to the movement of the individuals through the frame.
So stationary items in the video are black or dark.
Yes.
Right. The items that move are gonna be white or brighter color, is that accurate?
That is accurate.
And would this show motion for people and objects?
Yes, any changes in those values.
Okay, so if we see something black, that means it didn't move the entire time.
If we see things that are black, there's no difference in those pixel values.
Okay, but if we see something that's white, there's a difference in the pixel values because things are moving?
Correct.
Gotcha. Okay, and exhibit 13 on your screen, that looks like a fair and accurate copy, sorry, 14, looks like a fair and accurate copy of the video you produced.
Yes.
Okay, I would move exhibit 14 into evidence and request to publish, Your Honor.
Any objection?
No.
14 be received, you may publish.
Okay, and we can play it. Okay, and that was 15 seconds, right, Mr. Armstrong?
That is correct.
Okay, I'm gonna take it down from publication. I'm gonna bring up exhibit number 15. And exhibit 15 is entitled R23-1921 ACH01. Difference in large 4 times slowed down by 50%, right?
That is correct.
So again, on exhibit 15, we're seeing black and white again. Is that true?
That is true.
So for exhibit 15, you talked about the difference and how you did that. Is that the same in exhibit 15?
That is correct.
Okay. What is the difference between exhibit 14 and 15 then?
Difference is going to be that we now slow the video down by 50%.
Okay. And again, is this a fair and accurate copy of the video that you enhanced for this case?
Yes.
I would move exhibit 15 into evidence and request to publish.
Any objection?
No.
15 will be received, you may publish.
Okay, and we can hit play. Okay, and all the enhancements that you did, slowing down, increasing audio, this was all done consistent with your training and experience as a forensic imaging specialist with the State Crime Lab, is that true?
Yes.
And you didn't modify the content of any of the videos in any way, is that true?
That is true.
I have nothing further.
May I see counsel, please?
do you need to put in a different, or can we just work off these? You have to put one in, right?
Yep.
Oh, you got it in?
Yeah, this is the state's, that's all there.
That's the state, so you
Yeah.
just have to go through it.
And then just put it into the VLC media player.
Okay. All right, so what do I tell the judge? You ready to go and have it come up?
Mr. Shearer, do you want us to switch screens?
Yes, please.
All right.
Takes a minute. You ready? I'm gonna just see that it works. All right,
We're not seeing anything on the internal screens here. That's appropriate.
hang on. No, she didn't play.
Yeah, now you want it?
Oh, and yeah, you gotta get that.
Are you ready? Okay, there's something on the internal screen now. Are you ready?
Yes.
All right. Mr. Shearer, cross.
We don't
Sorry?
have it on our screen.
We
It's
have
on
it
ours.
This one.
Yeah, I can see it on their screen, I just,
It's on theirs.
oh, okay.
It's on yours, but not.
You want to turn it off and reboot it? That's the fix that they always tell me when I call Spectrum.
So technical.
It doesn't actually, it doesn't work though to turn off.
Well, then I have to take a baseball bat to it. That's the next step.
Well, I'm pressing the button. I don't-
The light is on.
It was before. Did it go off when I unplugged it?
You know, I didn't look.
There it is. It's on.
You have it now?
Yes, I have it working.
Okay, this is the end of Western civilization with all the technology. All right, we're ready.
Just one thing, there is some marking on it. I think
that was from me when I tilted.
it's cleared.
Okay, you're clear.
We good?
Mr. Sherrill,
Thank you.
ready for cross.
Yes, thank you. Do you call yourself agent, officer, or neither?
Mike's on.
Neither.
Okay. All right, and would you pronounce your last name for me?
Mr. Sherrill, can I ask you, where's your microphone?
I'll
Just
slide
move it over closer to you.
Yes, thank you.
Thank you.
Better?
That's better.
Could you state your last name again, please?
Last name is Armstrong, A-R-M-S-T-R-O-N-G.
Okay, and I've seen through your testimony, your credentials, and I understand that what you do is help or assist law enforcement in perhaps taking photos of a scene or taking photographs and trying to make them more visible or clearer, is that true?
That would be accurate.
And with regard to videos, you do kind of the same thing. You try to make them clearer. You might want to make them larger. You may want to slow down a video. Is that correct?
Yes.
Now, what you did with 14 and 15, can you tell me, and I apologize, I don't really understand what you call it. What is it, what you did?
So this is called absolute difference.
Absolute difference.
Correct.
Okay. My new hearing aids are not as good as I had hoped, but we'll deal with that later. Absolute difference. And an absolute difference, when I was looking at it, I was thinking of it as like a negative, but it's not that, is it?
It is not.
Okay. And you do something, and I'm so sorry, could you explain what it is that you're doing with regard to that?
Yes, with regards to absolute difference, what we can do within AMP5 is to see what difference in pixel values there are. And with regards to this particular exhibit, again, we're taking all the frames of the video, making it into a single image, and then overlaying the video on top of that single image and playing it through. Any changes in those pixel values will be represented in a lighter color.
Okay. And it's my understanding that some of what is causing it to be visible with some kind of color of some sort, or lighter shade, has to do with movement, is that right?
Yes, so when we take all the frames of video and merge it into a single image, any movement is now is not there. Anything that stays stationary is there. So when we're having those changes of movement, that's what we're seeing by overlaying on top of that single image.
Okay. Now, I'm not going to take credit for this, but somebody sitting next to me assisted me in trying to lighten it so that it was more visible in that format. And it appeared that by having by lightening it, brightness, other things could be seen. Did you try to do that?
I only adjusted the gain or the brightness within the video as it's seen here.
Can it be made lighter, brighter?
It's certainly possible.
Okay, if I show you something, will you tell me if this continues to be the video, but just perhaps more clear? Is that okay?
Sure.
All right, so I'm gonna ask my assistant to start the process of what, and you're on 14?
15.
15, okay. So, tell me when you're ready. All right, so can you see what she's doing?
Mm-hmm.
Can the jury see what she's doing? No.
I would ask that the jury not be allowed to see what she's doing. I think I have some objections to what an assistant is doing to modify a video even further than what Mr. Armstrong does. He didn't modify it this way, so I have concerns about foundation and what was done and how it was done by this assistant who seems to now be a witness.
If the questions are framed to this witness as to whether or not there can be alteration, and whether that alteration was within acceptable, I guess, guidelines based upon his training and experience, and he affirms that, then that modification can occur, whether it's manipulated by an individual at defense table or not. So as to the issue of foundation, the court will sustain the objection and allow for you to establish greater foundation for purposes of what you're attempting to do. And we'll see whether we can get this done in the time frame that I expect.
Can the witness see what she's doing?
Yes.
Okay, so, all right, so we won't do it with the jury seeing it until he is.
Okay, you're talking out loud. Let's get to questions.
Okay, sorry. All right, so I'm going to show you some raising the brightness on this, and you can see how it's being done. And go ahead and do that.
I'm gonna first object if we can tell the witness what type of video player we're in right now. It's different, the video player we played it in is slightly different than the one they're playing it in.
So that's a foundational objection. The
Sure.
court will sustain that.
Are you familiar with VLC Media Player?
Yes, I am.
Is that a reputable company?
I can't speak to, with regards to that, I know him only simply as a video player.
Pardon me?
I only know it as a video player.
Okay.
Not as for using it as any type of enhancement or clarification.
Well, if you see what is being done using this VLC media player, will that allow you to determine whether you believe that the changes are not altering the video itself, but perhaps enhancing it?
I have never received any training on VLC player as using it as an enhancement tool.
Judge, I'm not certain we're gonna finish at 4:30, because we may have to deal with this more extensively than I had hoped.
Is your witness available tomorrow?
Mr. Armstrong, are you available tomorrow morning?
I am, Your Honor.
All right, thank you. Ladies and gentlemen, we're going to break for the day. I'll ask you to retire to the jury room, receive instruction from Tom. Please do not discuss this case with each other or with anyone in your household this evening. I'd like you back here tomorrow at 8:20 so that I can get things going by 8:30, all right? That's it. Have a good evening.
All rise.